Hi, my name is Andrew Kinney. I'm a Social Security attorney at Hoglund Law Offices. Today I wanted to talk about submitting evidence after your Social Security hearing. Now, Social Security has hearings for people that are applying for disability insurance and supplemental security income. First, though, there is an application and, in most cases, reconsideration stage, and then after that you request a hearing and ultimately get a hearing. The hearing is with a federal administrative law judge that looks at your medical records and decides, based on that, your testimony and other factors, whether you could be approved for Social Security benefits. Now, the subject today is unique because most times you should, if at all possible, get your medical evidence in before your Social Security hearing, not after. But sometimes you don't have a choice. Usually what I see if we get involved in a Social Security claim and someone was unrepresented is that all the evidence wasn't at the hearing at the time. Usually, though, when that happens, we're helping at the level afterward, the appeals council level. So we're submitting evidence that should have been available before the hearing, way too late, I would argue. So in Social Security claims, it's important all along the way to make sure Social Security has all the updated levels at all the stages I talked about. But what is particularly important, at least by when your hearing is scheduled, is that you do a final push and get all the updates of records from all the medical sources so that they're available for the judge and perhaps experts at the hearing. Now, in the situation here at hand, when I'm talking about submitting records after the hearing, one of the challenges is that at some point after a hearing, the judge will have a written decision. The date of that written decision will essentially be the last day that the judge will look at this stuff for now. You have an unknown deadline after a hearing to submit medical evidence. What do you do about it? Well, if you have an attorney with you at the hearing, your attorney should ask to hold the record open. Don't make a decision, Your Honor, until we can get these specific records. Generally, judges have a deadline for that. Now, if you don't have that agreement, then you really don't know if you'll have time to get updated medical evidence. So a backup option, particularly if you're unrepresented, is to call your hearing office after a hearing and talk to the assistant for the judge and ask, can the judge not make a decision because I have, let's say, an MRI that I just got, or there was some evidence I forgot at the hearing? That's a good try, and it's better to do that than to hope that you get the evidence in time. So the basic idea here is you can get evidence in after a hearing, at least according to the current law, but it's not ideal. In fact, by any stretch of the imagination, you should at all costs try to get records in beforehand. If you do submit records after your hearing, your attorney should submit a brief, if it's possible, explaining why these records are relevant, in fact, why they're so relevant that you should look at them when you may have made a decision in the case but haven't committed it to writing. If you have more questions about Social Security benefits, applying for Social Security, or in the case of here, how should I handle my evidence in my Social Security claim, we're happy to talk with you. You can call 1-800-850-7867. You can also go online at hoglundlaw.com and look up these sorts of issues. Hopefully this helped today. Thank you.